Good afternoon. My name is Ted Lawn. I'm a lawyer practicing in Toronto. I was called to the bar in 1979, and I've been practicing as a sole practitioner since that time. I am pleased to have with me Steve Renaud. Steve is a chartered business valuator. He has been a chartered accountant for 28 years, and he has been a chartered business valuator for 23 of those years, the last 23 of those years. He has worked extensively on issues of business valuations and income determinations, and has been involved in many important and interesting cases over time. We were given liberty to choose our own topic for this presentation, and we talked about it for some time, and we concluded that we would choose those kinds of topics that were most unsettling for us, the ones that contained contentious issues, the ones where the law appears still to be unsettled, and where it can fairly be said that the state of the law in some cases is in fact quite disturbing. And so very broadly, the three topics that we're speaking of are topics which crop up time and again as follows. The first is the topic of double dipping, and we're going to be talking about it in relation to pensions firstly, and then other assets, including business assets. We propose to deal as well with the topic of the books of business of investment advisors, stockbrokers, insurance brokers, and the like. And we're going to be focusing on one subset of that, which is the deferred date of realization discount, over which there appears to be some controversy. And then finally, we wish to deal with the issue of interests in discretionary trusts. Firstly, are such interests property within the meaning of the Family Law Act? And secondly, if so, how do we go about valuing those interests? These are issues upon which both lawyers and accountants can provide useful insights. And we've chosen to do this together in the hope that even if we can't achieve some kind of consensus as to what the law is or where it should be going, that at least we can foment some discussion about these issues. Stephen, welcome.
Thank you, Ted. Thanks for the great introduction. I think everyone's looking forward to our discussion of these hot issues.
I asked a colleague whether he would like a copy of my article, and he said that he would rather chew off his own arm. I said, but look, there's also a chartered business valuator who's involved, and he walked out of the room. It may mean something.
Too bad we didn't have an actuary involved. That would have cemented it.
There we go. Steve, perhaps what I can do is to talk a little bit about pensions and double dipping, an overview of the law, and then we can get into some discussion about some fact scenarios.
Great.
The case of Boston and Boston is familiar to most of us. It's a judgment of the Supreme Court of Canada dealing with the issue of double dipping. And the general proposition is put early in the decision by Major J at paragraph 3, where he states, "It is generally unfair to allow the payee spouse to reap the benefit of the pension both as an asset and then again as a source of income. This is particularly true where the payee spouse receives capital assets which she then retains to grow her estate. So that sets out the issue. Continuing at paragraph 64, to avoid double recovery, a court should, where practicable, focus on that portion of the payor's income and assets that have not been part of the equalization or division of matrimonial assets when the payee spouse continuing need for support is shown. So we'll have examples of that point to illustrate what Major J means when he uses the language that part of the equalization or division of the matrimonial assets where the payee spouse continuing need for support is shown. And then there's an exception carved out to the general rule against double dipping, which is explained in paragraph 65 as follows. Despite these general rules, double recovery cannot always be avoided. In certain circumstances, a pension which has previously been equalized can also be viewed as a maintenance asset. Double recovery may be permitted where the payor spouse has the ability to pay, where the payee spouse has made a reasonable effort to use the equalized assets in an income-producing way, and despite this, an economic hardship from the marriage or its breakdown persists. Double recovery may also be permitted in spousal support orders/agreements based mainly on need as opposed to compensation, which is not the case in this appeal. So there's a rule and there's an exception. The title of this segment might well be, you can't double dip unless you must. This principle is further explained quite nicely in the New Brunswick Court of Appeal in a case, Flieger versus Adams. And I've prepared an article in which these cases are cited, so there's no need to be scribbling down these names as we go through them. In that case, the New Brunswick Court of Appeal summarized the authorities as follows. Where any economic hardship from the marriage or its breakdown persists, the award of spousal support on a variation application must give effect to the objectives of spousal support in a section 17(7) of the Act, where the satisfaction of the objectives in section 17(7) of the Act can only be achieved by double dipping, then the practice is and should be condoned. The spousal support award must include a significant compensatory factor arising from the length of the marriage, the fact that the spouse gave up a career to raise children, and a significant needs-based component taking into account the relative means and needs of the parties. It should also attempt to adjust to some degree for the disparity in the standards of living of the parties, taking into account the standard which they enjoyed during the marriage. So the carve-out is fairly large, and as stated by one of the authorities, it's kind of a situation where one is concerned that the exception has swallowed the rule. I'm going to, at this point, refer only to one case which fairly neatly applies the principles in Boston. This is a British Columbia case, Ford versus Ford, from 2014. In that case, the husband was 49 years old and the wife 48. The parties had been married for 26 years and had 2 children who were now adults. The marriage was a traditional one, The husband was initially ordered to pay spousal support of $2,905 per month based on an income of $109,000 and change per year. The husband suffered some health problems and was discharged from his employment. His income was then comprised of pension income, disability payments, and disability income, all of which totaled some $99,000 per year. Of that, the husband's pension income was $32,428 annually. The court noted that the husband had $52,000 worth of assets and $92,000 of liabilities. It noted that the wife had locked in RRSPs in an amount that they do not set out, further assets of $55,000 and debt of $10,000. Voice J found that the husband's pension should not be factored into his ongoing spousal support obligations. At paragraph 22, he states, though Ms. Ford cannot access her locked-in RRSP, the reality is that she has a very significant asset that is growing considerably. Equalizing spousal support payments at this time disregards the general rule in Boston. It also inhibits Mr. Ford's ability to similarly build his assets or to acquire an asset of some substance at some point in time, or to pay off the greater amount of debt that he presently holds. So that fact situation cannot disturb us. The fact is there was plenty of income to go around, and the wife faced a reduction in her support, but not a fall off. It was not a cliff. In other situations, the situation might be much more dramatic. In other words, typically, when a person retires, the only income that they will have is the pension income. And if that's already been equalized, or almost all equalized, what will we do then? So you have before you some overheads. Is that what they call them? Is that what the kids?
PowerPoint slides, perhaps?
Is that what the kids call it these days?
I'll have to ask my children. Okay, so let's start with the first situation here, and this is obviously very similar to the Boston case that Ted just went through. So we have a spouse who works for an employer with a lucrative pension plan, and say we expect, at V-Day, we expect that the spouse will receive about $50,000 a year on retirement at about age 65. But at V-Day, the spouse being just 55, the titled spouse, he's only earned, say, about $40,000 per annum of the $50,000 per annum expected future pension income. You take it to your friendly actuary who comes up with a value of, say, $600,000 that gets included in the husband's net family property. And for simplicity, let's say the house is worth $600,000. Husband keeps his $600,000 pension, wife keeps her $600,000 house. Everybody goes their merry way. Now comes retirement. Husband gets $50,000 a year of pension income, and let's assume very little other income. Let's assume something similar for the former wife, very little other income. Husband's line 150 is going to be very easy to calculate, $50,000. How much does the husband include in his income for support purposes? Well, if we go to the child support guidelines and we read them, it says you start with line 150. That's a host of adjustments to make. None of them have to do with double dipping. The guidelines say income is $50,000 a year. However, husband's going to say, clearly it's inequitable to make me pay support on the full $50,000. I've already equalized my ex on the first 40. The husband's going to argue it's equitable to pay support on the excess $10,000 that he earned post V-Day. The wife is going to say, perhaps a la one of your cases, Ted, but I can't live on that lesser amount of support. So you've got good arguments for both position A, 10,000, or position B, the whole 50,000, right? And hopefully you don't have this situation, because in this case, what might happen, Ted, I think you alluded to it in the case, is the court understands that under the double dipping principle, the support payer should not include the full 50 in his income, but may be forced to.
Yes, it's interesting that in pension situations that we are referring to income that's calculated for the purpose of the child support guidelines. And we understand the rationale for requiring child support based upon line 150 income and adjustments. And we can understand the rationale for saying, look, the child didn't get the benefit initially of the equalization of the benefit of the pension, and so that shouldn't affect the entitlement to that proper amount of child support. It's interesting as well, I think, that in your work, you're asked to calculate income for spousal support issues, but you're asked to do so based on the child support guidelines. Is that what you find in your practice?
In general, yes.
And why is that?
Well, my understanding of the spousal guidelines is they say, A, start with the child support guidelines calculation. Now, this is where counsel has to give the valuator instructions. The valuator on his or her own should not be saying, oh, double dipping, and therefore I'm going to reduce income for support purposes. If counsel advises the valuator may wish to do in his or her report with double dipping and without double dipping to allow the court to make the right decision.
It seems to me that in your role as an expert, which is quite different than a role as an advocate, the fairest way of bringing all of the information to the court is with both of those scenarios.
Agreed. Okay, so that was the first example we had of double dipping. The next one we refer to as the classic situation. Classic in the sense that if one of the parties is a business owner, this issue may arise. So follow this example here. You've got a title party owning a company, a very lucrative company. It earns $500,000 a year before paying any salary to the owner. Let's assume that fair market value of the salary to the owner is $200,000 per annum. So in business valuation theory, the way you calculate the company's maintainable earnings is what's it expected to earn and reduce that by what it would have to pay an arm's length individual to replace the shareholder. So in this case, that's $200,000. So the company makes $500 less the $200 it has to pay someone. Therefore, its ongoing maintainable earnings are $300,000 a year. For simplicity, we've given the example that the business is valued at 4 times earnings. So the business is worth $1.2 million. And if there's nothing else involved here, an equalization payment of $600,000 has to be paid. Now the company continues and life goes on as expected, and the company continues to make $300,000 a year after paying the owner a $200,000 salary. The question now is, what is income for spousal support purposes? Now, we've already talked about for child support, so let's stick to spousal support. The support payors, line 150 income, will be the $200,000 a year of salary. However, the guidelines also say, and look at the pre-tax corporate income of a controlled corporation. In this case, the company is 100% controlled by the title party, makes $300,000 a year, and let's assume again for simplicity's sake it's a service business. So there's no argument here that he has to buy new machinery, replenish inventory, things like that. The $300,000 that it earned was available to be distributed. The title party will take the position, my income is my line 150 income. The other $300,000 that's left in the company is the same $300,000 that we capitalized for business valuation purposes. How can I be expected to pay support on a number a lump sum of which was already calculated and included in my property. It would be double dipping. Conversely, the support recipient says, read the guidelines, my friend. Your income is the $200,000 line 150, plus clearly the $300,000 available to you. We have a conundrum, Ted.
A couple of things. Could you a little more closely define the concept of maintainable earnings? In your work in income determination, how do you go about determining it, and what is its importance?
Okay. We're trying to simplify a complicated area, Ted. Right? Obviously, when we value a business, we look at what it's earned in the past and then use that to calculate a range of expected earnings on a go-forward basis, because what's the value of a business? It's the present value of what it's expected to earn in the future.
Yes.
So that's what we call maintainable earnings. What would a reasonable person expect this company to continue to earn on a go-forward basis? And depending on the industry, like in this case, we said 4 times earnings. I can tell you it depends on the industry. If it's a high-risk industry, we might have used 2 times earnings. If it's a low-risk industry, we might have used 10 times earnings.
The point being that the future anticipated income of this business has already been equalized. So your point is, why are we doing it again?
Well, it's not the future income. The value of the business, which is a function of its expected future income, has already been included in property. So
Yes.
the title party has a very valid argument in saying, I should only be paying support on anything that I earned above that capitalized $300,000 amount, because my spouse already got a risk-free guaranteed payment up front of what the expected future payments were going to be. Why should I keep paying support on that? And of course, there is also an argument for the support recipient who says, however, you're expected, in this case, to receive $1.2 million sometime in the future when you eventually sell the business, and you're going to keep earning that $500,000 a year. So why shouldn't you pay support on the full $500,000? They both have valid arguments.
It seems to me that the courts have not provided clear guidance with respect to this issue.
I think the courts have actually said, in this case, Ted, that you will continue to pay support on the $500,000. Right? I've seen way more cases where the full amount is included in income rather than the lesser amount. Okay? Again, we'll compare it to the next situation, which we call the extreme situation. In this case, I think a court would be wrong to include the higher amount.
Before you go there, let me talk about a recent case that alludes to some of these issues. From August 20, 2014, we have the judgment in Berta versus Berta, Ontario Superior Court of Justice. And this was a case in which the parties were married in 1982 and separated in 2010. I guess that's 28 years. The wife took early retirement. The husband had established a business, the shares of which were equally owned by the parties. The parties enjoyed a lavish lifestyle funded by the company's profits. After separation, the husband purchased the wife's interest in the business and sold the matrimonial home and divided the proceeds equally. The wife nonetheless sought spousal support. Justice Harper, in that decision, summarizes the arguments and has some discussion that goes like this. So he talks about the husband's argument, firstly. Ray argues that it would result in double recovery for Joan if his income from ACCE, that's the name of the company, is considered for the purposes of spousal support. He submits that Joan was paid her half interest in the company. She chose to put the money she received in safe assets. She also chose to place that money in certain assets that she did not initially disclose. Ray submits that Joan could and should maximize her earnings by using the money she received from her equal share of the company, and it would be unfair to allow her to take that share, park her assets, and then claim that she's entitled to equally share in the income Ray is receiving as a result of his ownership and efforts in the same company she sold her interest in. So that's the argument. And although this wasn't critical to the decision here, Justice Harper states at paragraph 97, in my view, there might be an argument that Joan was paid her interest out of ACCE and that the value was determined on the basis of a calculation of what the maintainable earnings of that company would be over time and capitalizing that amount. The argument may well be that Joan would have already been paid the capital value of the future earnings. However, in this case, there was no evidence of such calculations that may have been made in order to arrive at the value the parties agreed to when Ray bought Joan out of the company. That, I guess, is in furtherance of the view that it's all done, that it would be a classic double dipping for her to get support from the same source.
Right. But she did get support, right?
Yes.
And the reason is Ray's income was very high, right?
Yes.
It was a profitable company, and despite the fact that she got millions of dollars, and even when you add back the monies that she didn't disclose, if she had invested all that money at, say, a reasonable rate of return, and the woman was in her late 60s, if not early 70s, so no one expects her to be investing in high-risk, high-return investments. So let's say she was getting a 5 or 6% return on $3 million of investable assets. She's expected to make, say, $180,000 a year. If Ray is making $800,000 a year, it's difficult for Ray to argue that the discrepancy in their income isn't too high, especially considering the lavish lifestyle that the judge referred to. If they were living on more than $180,000 a year of expenses, and Ray can afford to keep her living in the same lifestyle without diminishing his own significantly, the court has no choice, despite the fact that, yes, it might breach the double dipping concept.
In that case, Justice Harper was very complimentary of a chartered business valuator that was involved in the case, and I'm wondering if you're in any way related to an S. Renault that was involved in that case.
It was a great case to be involved with, and I was engaged by counsel for Mr. Berta, and I'm very happy with the outcome. The judge liked our numbers very much. Okay, so let's continue now to the extreme situation, and the extreme situation deals with a business that you'll see has no value at the end. So with data separation, one spouse owns a business that earns royalties. Let's give the example. It earns $200,000 a year in royalties. Say I wrote a book, and I'm going to get royalties for the next 5 years of about $200,000 a year. I don't have to do anything else. The book's already written. So I'm entitled to this money on an after-tax basis. It's worth about $500,000, right? $1 million over the next 5 years, less 50% tax. It's included in my NFP at $500,000, and I equalize my former spouse by giving her a check for $250,000. We have no other assets or liabilities. Now, the next 5 years, my line 150 is going to show $200,000 a year.
Yes.
Do I include any of that in income? And the answer here has to be no. Despite the fact that the guidelines say, well, line 150 is 200, if I were to pay 1 penny of support, then my former spouse will end up getting more than $250 on an asset that was worth in total $500,000. The income stream is the value of the asset. At the end of 5 years, I'm not going to have a business that I can sell for $1.2 million the way we had in the other example. I'm going to have the square root of zero. So in this case, I think everybody, if they understand this, should agree double dipping has to be considered and no spousal support can be paid on that.
Yes. Another way to look at it is that she received her spousal support in advance.
Exactly. She was lucky enough to get that.
Okay.
Okay. The next situation is, I call it the tax situation because you've got a company that has marketable securities or a real estate holding company. In each case, there's an accrued capital gain. So let's use the real estate example. Title party owns a corporation. It owns property with a $100,000 gain inside. When we value the business, we already consider the fact that the property is worth $100,000 more, and we already consider the fact that the capital gain is taxed at a much lower rate than regular income in arriving at the husband's NFP, and therefore the equalization payment is made considering all that. A couple years go by, husband causes the company to sell the real estate, company realizes a $100,000 gain and pays him a dividend, including a tax-free capital dividend. Should any of that capital gain, should any of that tax-free dividend be included in his income for guidelines purposes? Well, again, like everything else, we have two arguments. Argument A, based on the strict reading of the guidelines, says pre-tax corporate income of a wholly owned company, of course you include it. And then 19(1)(h) adds to that by saying, oh, look at that. A significant portion of income was earned from a capital gain or a tax-free dividend. Gross it up. But the converse argument is, whoa, there's been no gains since V-Day. The spouse was already completely equalized on the value, including the fact that the taxes would be lower. There's no reason for any further support on that. If the title party pays 1 penny of support, then the non-title spouse will end up with more than 50% of the value.
Yes.
Here's a tax situation, but it's the converse. And I don't know how often you'll see this. I've seen this at least twice in the last year, so I felt the need to throw it in. Instead of an accrued gain, we have an accrued loss. So the husband had a business with marketable securities. It was an operating company, but it also had extra capital, so it bought shares. Well, let's assume it bought shares in oil and gas companies, and we all know what happened to those. Yes. It declined in value by 1/2. So at V-Day, the company had marketable securities purchased for $200,000, which were only worth $100,000. So in valuing the company, we considered the $100,000 capital loss. It was worth $100,000 less. Now a couple of years go by, the husband causes the company to sell the shares and realize that $100,000 capital loss. But in the same year, this profitable company made $500,000 of business income. So the financial statements show it made $400,000 in total. The guidelines say you include the pre-tax corporate income of a controlled corporation. Should we include $400,000 or $500,000? Well, the title party is going to say include $400,000. That's what the guidelines say. The shoe's on the other foot now. The non-title party says, whoa, we already considered that $100,000 loss back at V-Day. I shouldn't be penalized now by considering a $100,000 loss that had been economically realized before V-Day and is only triggered on paper now post V-Day. Shoes on the other foot.
What seems to be is that one starts with line 150 and the guidelines, and then takes a pause, as in this situation, and says, wait a minute, is this really the fair result? And the overriding principle, of course, in all of this is that, yes, we'll have rules and guidelines, but the Family Law Act is clear that what we're doing is we're trying to achieve an orderly and equitable arrangement with respect to the financial affairs of the parties. And so it seems to me that one approach would be, okay, let's look at the line 150 and let's look at the guidelines, and then let's take a pause and see if that's orderly and equitable. It means then that rules become less rules but more guideposts, but perhaps that's the nature of family law. And family law has had to do a number of things to achieve fairness and equitableness. It's had to stretch some principles, and we'll get to those in a moment. One of them is as to what is property. It's a more expansive view of property than in other areas of law.
If we lived in a perfect world, Ted, double dipping would always be considered. But in a perfect world, you never have a risk of one spouse being destitute.
Right.
That's the problem.
Yeah. The hard cases are the ones where there's a cliff.
Right.
And the effect of not allowing a double dip is dramatic.
It's very difficult for a judge to say to the non-titled spouse, it's too bad you blew all your money early. Go live in the streets.
Exactly. Yeah. And take your children
Yeah.
with you in some cases.
Okay, so now we go to the next slide. Is just a couple of other examples of where double dipping should be, you should keep an eye out for. A bonus receivable, let's say you have a spouse who earns, it's a senior executive, so they earn, say, $150,000 a year of salary, an annual bonus close to their full salary. So let's say it's $100,000 a year that gets paid a month after V-Day. There's a good argument that 11/12 of that bonus should be included in net family property. It was already earned, it was expected. So if that's the case, you have to make sure that the following year you don't include 100% of the bonus, which is clearly in line 150 of the recipient spouse. Don't include that in income for spousal support purposes because 11/12 of it was already equalized.
And in recognizing it, I don't think there's any argument, but that is the appropriate.
Right. And then similar logic applies with employee stock options, restricted shares that are awarded as quasi bonuses, and also what happens when you've included the value of a business at V-Day, and then years later the title party sells those shares and realizes a gain.
Can you help us with the meaning of the phrase restricted share units?
Employees who work for public companies, and generally it's senior employees, may be rewarded with shares of the company that take a number of years to vest. So the vice president of Bell Canada might be awarded $100,000 a year of these restricted shares. Basically, they're golden handcuffs. If you stick around 3 more years, these shares vest and you get them. However, until then, they sit in escrow type. So that those are referred to as restricted shares. And they have a value at V-Day, even though they haven't vested yet. And then 3 years later, they will hit the senior employees line 150 because they're taxed at that time.
Yes.
Okay, so now we're switching topics. We're going to the topic that Ted alluded to before, the deferred date of realization discount. And this arose because of a number of cases involving investment advisors and insurance brokers. These are employees, but unlike most employees, there's an asset value to be determined for net family property, and that's their client list. A typical stockbroker or insurance broker at a large insurance company has a client list that has a value because your clients, let's use a stockbroker example, you may have 1,000 clients who each have, say, $100,000 of assets that you manage, and help me out with the math here, that could be, say, $100 million. If the company charges 1% a year to manage those investments, you've got $1 million a year of commissions that are earned. Clearly, there's value to that. And the company, be it CIBC Wood Gundy or Scotia McLeod, they don't want that investment advisor to take their clients elsewhere. So they offer that investment advisor a very handsome reward upon retirement if they transition their clients in an orderly fashion to a younger investment advisor at the same firm. So we know that at V-Day, these employees have a valuable asset.
In some cases with the larger firms, there are policies in place which contain formulas for how the broker is to be compensated.
Exactly. So we can't ignore the fact. And for years and years, the courts were unaware of this. But over the last decade or so, the courts have become aware of this, and there have been cases to determine, A, was this even property? Because the brokerage firm will say, oh, the clients belong to us. They don't belong to the individual. However, economically, we've seen when investment advisors do decide to leave and take their clients, they can take a significant amount of clients with them. And also, they get paid a handsome reward on retirement. So there's definitely a value there.
This has been established in Ontario in the cases of McLean and Mavis, the fact that these things are property. There's some difficulty with valuation of these kinds of interests at some points. I mean, if there's a formula in place, then I suppose that makes it a great deal easier. Can you comment upon that briefly?
There's significant value here, and the problem that the courts have had is that they have a hard time separating the fact that these are employees and not business owners, technically. So if it was a business owner who had goodwill in their business, and that's what these client lists are, it's goodwill.
Yes.
Everybody would agree. You include that in net family property.
Very briefly, in the Mavis case, that was a case that seemed to introduce this notion that there should be a deferred date of realization discount on the value of this interest.
Right.
Then we have a later case, Green versus Green, which doesn't do that.
Let's go into detail about that deferred date of realization discount. So at V-Day, everybody agrees if the investment advisor were to retire that day using, say, the CIBC formula, the book of accounts would be worth $600,000.
Yes.
However, the courts have said it's not fair to include the $600,000 in this employee's net family property, because if he were to notionally retire, how could he then pay support? It's not fair to make him include the full $600 in NFP and still make him pay support on it. So that's why they said, let's say the employee was 50 and 15 years away from expected retirement, discount the $600,000 to say $500,000.
My question is, why should this type of business, be different than any other business?
We're in full agreement there. It makes no sense, because if you've got an investment advisor, as we give in the example on the next page, married to a dentist, the dentist has to include the full amount of goodwill in her net family property. The investment advisor gets a discount on the value of his goodwill. We're going to have one angry dentist there.
We are running quickly out of time, and our favorite topic we haven't started yet. Shall we move right to there, just
Sure.
for a few minutes, and summarize that very quickly? Just in short, first of all, a discretionary trust is one in which trustees are given absolute discretion concerning the allocation of the capital and income of the trust fund beneficiaries. So the first question is an interest in a discretionary trust property within the meaning of the Family Law Act? The short answer is yes. The more interesting discussion would have been, well, how in the world does that work, when in trust law the answer would be no. But clearly, for family law purposes, this kind of interest is clearly property. We move then to the rather more difficult question of how do you go about valuing such an interest. Start, if you may, with the concept of fair market value and how it might apply in circumstances where trust interests are non-transferable. and then move on to the concept of value to owner, if you may.
Okay. So the Family Law Act dictates that property is determined for net family property purposes based on its fair market value at the valuation date. And it's quite simple in most businesses. Well, not overly simple, or I'd be out of business, but what could it be sold for to an arm's length party? So we talked about the dentist before. Dental practices sell on a regular basis. There's lots of data out there, and that's how we calculate the value of a dental practice. What could it sell for in an orderly fashion at the valuation date if it were put up for sale? However, Ted, you are the scion of a wealthy family, and you've decided to leave all of your children an interest in a trust, right? And it pays them $100,000 a year each. They can't sell that interest, try as they might. They might like to sell it and get a lump sum up front. It's a non-transferable asset. So what do? The courts have said where property is to be included in net family property but is not transferable, we don't use the definition of fair market value. We use the definition of value to owner. So the question is, what would the trust fund baby pay not to have this $100,000 a year entitlement taken away from them? And that's going to be a pretty big number. So there's no doubt about it. There is a high value to a trust interest.
In my article, I rely heavily on an article written by Margaret R. O'Sullivan entitled Valuation Issues in Discretionary Trusts. And she states as follows: using the concept of value to owner, the issue becomes not what one would pay for a discretionary interest as in a commercial transaction, but what one would pay not to lose the discretionary interest, i.e. its value to the owner. You mentioned to me before we started about how much one would pay not to take the chance of losing an interest.
Right.
Could you just amplify that?
Well, let's say, for example, someone is an income beneficiary of a trust. And on average, the distributions have been, say, $100,000 a year. I'm 45 years old. My life expectancy is 43.2 more years, right? We would calculate what's that $100,000 a year worth after tax? And then what's the present value for 43.2 more years? That's what my income interest is worth. Now, there may be other adjustments to be made, right? For is my interest vested or unvested? Is my interest subject to control by arm's length parties, or am I the trustee of the trust? Who makes the decisions and how the assets are invested? There's a whole bunch of other issues, but that would be the starting point.
Let me, as we wind down here, and we're being motioned to stop it quite soon, in valuing discretionary interest, one factor appears to be control. What is the degree of control that a beneficiary has over the disposition of the trust proceeds? So if, for instance, the beneficiary is also a trustee, if, for instance, the beneficiary also has the power to remove trustees, and if, for instance, there's been a history where all of the distributions have been made to this beneficiary, then it seems to me that a court will likely find that the entire corpus of that trust is the property of that beneficiary. Okay, so that's a pretty clean example, but I would suppose that the issues are not always that straightforward.
You've given us the extreme case. So prior to separation, husband establishes a family trust, makes himself the trustee, makes himself the only beneficiary. I agree. Whatever's in the trust, I believe a court would say 100% belongs on the husband's side of NFP. Very seldom are things that clean cut.
Yes.
However, if, let's say, husband's parents set up the trust, and,
yes,
and he's the only beneficiary, and husband's parents, there's no reason to believe they don't act in concert with the husband, then again, I think a court would say pretty close to 100% of the value belongs on his side of the NFP.
Yes. what if it were pretty clear that the parents will defer making the distributions for as long as they can?
That's clearly a discount on the value, right? And we've also got issues here as to how much. Let's say the trust used to pay the guy $100,000 a year during marriage. All of a sudden, post-separation, the trust can still afford to pay more. It just pays less because the husband's parents said, "We don't want to make distributions if it just means that our son has to pay more support," right?
Yes.
Thank God, that's a legal issue.
What if there's an income beneficiary and who will be entitled to income for a lifetime, and then there's another beneficiary who's the ultimate capital beneficiary? That will affect it as well.
Oh, no doubt about it. So let's give a simple example. There's $1 million in a government bond sitting in a trust.
Yes.
And the husband in a separation is the capital beneficiary, and let's say his mother is the income beneficiary. So she's going to earn the income on this, and we would look at the actuarial tables. She's got 20 more years to live actuarially. So
Yes.
the whole trust is worth $1 million. The present value of her income payments for the next 20 years, for argument's sake, might be $200,000, let's say. In which case, presumably, his capital interest is now down to $800,000.
Or looked at another way, you look at the million, what is the value, the present value of the $1 million 20 years
Right,
from now?
exactly. You could look at it that way too. It should give you the same number. And then what happens if, in addition to having the income rights, his mother also has encroachment rights, right?
Yes.
His father, who presumably left this spousal trust, said, I don't want her to be financially hard up if she gets sick. So she's allowed to encroach if she has higher medical expenses. That's clearly another risk, and therefore another discount in arriving at the value of his capital interest.
I want to read to you a passage from a case from the English Court of Appeal in Charman, Charman versus Charman. It is essential for the court to bring to it a judicious mixture of worldly realism and respect for the legal effects of trusts, the legal duties of trustees, and in the case of the offshore trusts, the jurisdiction of offshore courts. In the circumstances of the present case, it would have been a shameful emasculation of the court's duty to be fair if the assets which the husband built up in Dragon, that was the family business, during the marriage had not been attributed to him. So that seems to me a very strong signal that family courts resent their good work undone by a sophisticated estate and trust plan.
Right.
That's the beginning and end.
We've all seen that courts like an equitable distribution of property and income.
Yes. Yes.
Okay, do you want to continue?
Let's continue a little bit and see if
Okay.
we can just touch upon a few very interesting, although esoteric points.
Okay.
Only an accountant would think up this kind of stuff.
Thank you. We have a scenario here where we talk about drawdown of shareholder loans. Here's an example. Wife owns a business, and
You say thank you, but
I assumed you were talking about me, and I assumed you meant it in a flattering way. I'll retract my thank you. So she owns a business, and at V-Day, she had loaned $100,000 to the company.
yes,
The $100,000 was collectible, and therefore the $100,000 is included on her side of the net family property.
yes,
A couple of years go by, the company earns $200,000,
yes,
which presumably should be included in her guidelines income. However, the company used the first $100,000 of that to repay that loan to her.
yes.
Question now is, how much of the company's income should be included in her guidelines income? Should it be the whole 200? Should it be 100? Might it be none? The husband in this case would argue, of course you include the whole 200 in her income. And she'd say, no, I had to use 100 of that to repay a loan. But he says, but you repaid the loan to yourself. By definition, you had access to the income, therefore, it should all be included. And she would rightfully argue, however, if that loan was owed to a third party, to a bank,
Right.
we would all say, oh, the bank demanded the 100,000. Clearly, I didn't have access to the whole $200,000 of income. And given the fact that if we treat the bank as a third-party lender and herself as a third-party lender, treat them the same way, we'd already included the 100,000 owed to her as a separate asset. Is it fair to now deny her the same treatment that she would have had she owed the money to a third party? We would have said the 100,000 is not available from the company's income.
She would say to him, you've already had your share of that.
Yeah.
Let's deal with one more situation.
And this is the one that we discussed earlier, Ted and I,
Yes.
off camera. And it had to do with, we're all aware that there's income tax gross-ups on certain types of income earned by the title party or the support payer.
Yes.
If the support payer earns unreported income or puts personal expenses through his business, right? We all understand the courts say there's 100,000 a year of unreported income or 10,000 a year of personal car expenses put through the business, add those amounts back, and pursuant to 19(1)H of the guidelines, we have to add an income tax gross up.
Yes.
Okay? So now, we have HST on all of these expenses, and I've always asked this, why do the courts ignore this? If a guy puts 10,000 of car expenses through his business, we add the 10,000 to his income, and we add the income tax gross up. We've forgotten that in addition, he saved 13% of that 10,000. He would have had to pay HST in Ontario of
Yes.
13%. Now his company gets to recover all that HST. So really, instead of adding about maybe 95% to his income to gross it up, we should be adding close to 120% because he saved income tax and HST. It's an argument people might want to make the next time they're on for the support recipient and the support payer is not the most honest of taxpayers.
The reason we don't want to do that is because we know that in order to make that argument, we're going to need to spend money on people like you. And it's bad enough that we have to spend money on people like you to deal with the big percentage stuff, but we're not going to do it when it comes to the 13%.
This is where I have to differ with you, Ted. There are worse ways for lawyers to spend their money.